This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's family law night. So if you've got questions about child support, divorce, alimony, this is your chance to call in and get your questions answered. You can be live on the air. Call in the 31 Law Call number 256-536-0077. You can call in or you can text your question to that same number. We have lots of your text questions coming in. You can also email a question to us on any legal topic any day of the week. You send it to lawcall@waaytv.com, and when we get to a show that's on point, we will have some of those questions, even on family law tonight. William Meservey is here from Timberlake, League and Brooks. Good to have you here.
Always glad to be here, Sharon.
Family law, though. You don't do family law, so
I don't do family law.
We brought somebody to join us.
Two experts who do. So Sharon Doviet, who is our host, of course, practices in the realm of family law each and every day. And we have with us Kobe Boswell, who runs Next Step Family Law, has been in practice for 12 years or so. And happy to have you tonight, Kobe.
Thank you guys for having me. I appreciate it.
Absolutely. So I'm excited tonight because I'm going to learn something. And so I have brought a list of the most commonly asked questions to me that I don't know the answer to.
Because people ask you things all the time, right?
Yeah, they do.
Just like they ask us things that we don't practice.
Sure.
Yep.
Cool. And we encourage that. I think lawyers do. You know, if you have a client and they have a question, reach out, because if you don't know the answer, you're going to get them to someone you trust, you know, that can answer that question for them. But it should be fun.
It's going to be fun. Well, we get some of your calls logged in. We've got tonight's You Make the Law Call clip. We pulled some video off. This is a personal injury case. So we're starting off in Williams area. People at work, and there's a hole in the floor there that you see that they're dropping things through, stock and things. Okay, watch the guy that's coming now, though, and he is not paying attention to what he's doing. So if he's just okay, he's going to be okay. There's even a camera down below, and you get to see he's okay. All right. Maybe he's a customer that's walking through, or maybe he works there and he was on his phone. So from a personal, thank goodness he's not hurt too bad.
It is fortunate. The most amazing thing to me about this video is the worker sees him and then just looks back up and continues to work. So, you know, the first thing to know is that to have a personal injury case in the state of Alabama, you have to suffer an injury. And that sort of impact could cause a back injury maybe or something like that. But, you know, in a premises, on the property of a company, you know, there's going to be a duty of the occupier of that premise to protect against hazards, right? Okay. And sometimes the best example I can give people is a ballpoint pen. It's got a sharp point on it. If I stick that in my pocket, it could poke me, right? Yeah. So that's a hazard. So if a company knows of a hazard, like we've removed part of the floor and there's now a hole in it, they have a duty to remedy that hazard. But sometimes you can't always remedy it, right? You need a sharp point to write. In this instance, they needed to remove part of the floor to get stock up and down the stairs, I guess, or up and down between floors. And so when that's the case, you then have a duty to limit that hazard. This pen has a retractable point. Others have a cap that goes on the end of it, right? And you can limit a hazard such as that if you think about any big box store. Yeah. When they get the forklift out, right?
It's quite the show.
They bring out, you know, multiple staff, and they tape off the aisles that it's going to be working on so that no one can accidentally be up and down that aisle.
There was a lawyer behind that at one point, wasn't there?
I'm sure that there was. And so, you know, they limit the hazard, right? And then if you can't limit the hazard, you have to warn against it. So think about a wet floor. You know, there's no way to mop without water. And so when the floor's slick, you got to put up those yellow signs that warn customers that, hey, there's a hazard here. And so they failed, quite obviously, in that video.
I didn't see any of those things.
Right, to either limit or warn against the hazard. And so that's the type of thing that would sort of be a nightmare situation for a business owner.
So tonight it's family law night. Call in your questions. We had gotten this text question in earlier. Somebody who's a college-age person and says, this fall I'm moving out, I'm going to college. If I'm under 19, do I still have to obey the rules and go visit with the non-custodial parent?
You know,
so we talk about this a little bit.
Unfortunately, sometimes we have to give answers that children don't want to hear, but unfortunately, as long as you're under the age of 19, you're still subject to that order that the court has entered. So yes, the court can still enforce it, but we were talking about it. If you're at college and you're sitting there and you're in class and your parents trying to get you to come home to exercise the visitation, I think it's unlikely the court's going to ask you to sacrifice something for college or something that you're doing, a job or whatever, if you've moved off. But technically, you're still subject to that, and unless there's a good, valid reason for why you are not coming home, then yes, the court can enforce that order.
We talked a little bit about, it seems like, now we can't tell you don't obey the order. Obey the order. But it does seem like judges are being a little more flexible, especially with older teenagers. We're seeing Madison County judges kind of say, you've raised a child, you've given them a lot of input into their lives, and now you want me to make your child do something. And now, not with small children, but older children, they're kind of saying they're not putting that much effort into making them follow the law. But we have to tell you, follow whatever your court order says.
Very good.
You got a list for us?
I do. So one of the most commonly asked questions that I get at the office is, if I get a divorce, will my spouse owe me alimony?
That's always a tough one, right? That's always a good question.
It kind of depends on who's making the most money and what you've done and the length of your marriage. So do you want to address some of those?
Yeah, I mean, alimony is not just a hard number. It's not a calculation under our law. It's really fact-based. It depends on, like you said, how long the marriage is, the disparity in the income, the lifestyle of that marriage, conduct of the parties during that marriage. There's a lot of different factors that go into it. But the most important one, I think, is a need-based. And so you have to establish for the court that you need this alimony obligation. Otherwise, the court's not going to impose that alimony obligation just because you're asking for it.
And there is fault-based divorce in Alabama, but you can also just get divorced because you're incompatible. If you want a divorce, you can have one. But fault, adultery and things like that, plays into the alimony situation, and fault more so than just maybe your reason for wanting the divorce. It might mean money.
Well, and Sharon, that leads me into question number 2 on my list.
Okay.
That I often get is, if the divorce is at fault, right? So if a spouse cheats on another spouse or something along those lines, will I get more in the divorce? Maybe.
Like Kobe said, there's not a calculation for alimony, and more so these days, judges really don't care. They don't want to hear it. If all you're wanting is just to be able to say, I got the divorce because he cheated on me. Adultery, they really don't want to hear it. They don't want to hear you argue all that.
Well, and I go back to the whole need-based thing. Just because somebody has committed wrongdoing in the marriage and cheated during the marriage, if they don't have the ability or you don't have a need for alimony, the court's not going to do it just as punishment just to do that. There has to be some sort of justification for why that money needs to be paid by that spouse.
And even if you can show the other spouse was really terrible, they're pretty much not going to get nothing. The judge is going to start with where 50-50 is and move it a little bit, maybe give you 60 and the other person 40, but it's going to be hard to get it way beyond that.
Well, just so our viewers know, right, because in these type situations when children are involved,
yeah,
one spouse is likely going to be paying child support already.
Right.
Correct? And that money is for the benefit of the children.
Right.
And for the other spouse's ability to take care of those children.
Yes.
And so what exactly is alimony then?
So alimony would be for if one spouse was making significantly more and you had a lifestyle, you were living a big grand lifestyle, maybe that spouse helped put you through law school. And so they or their family put money into your business, and they've created the ability for you to make more money than they do. Maybe alimony would make sense in a situation like that.
Sort of a return on investment.
Return on investment.
Well, and I think you brought up a good point, too. I mean, if you're already paying child support on top of that, finding the money to pay the spousal support is also part of the problem in there. There's got to be enough money to go around to be able to do that. But the spousal support will be for the benefit of that spouse alone and their lifestyle, and not necessarily directed towards the kids or what the best interest of the kids is at that point.
They're telling me we've got a caller waiting. We've got Howie on the line with a question. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, hi. I've got a question about it involving a divorce.
Okay.
I bought a house at a sheriff's sale that resulted in no excess money from the sale, and the gentleman who owned it bought it before he got married and kept it totally in his name. And when they got divorced, they had a settlement agreement where the house still remained in title in the husband, but the wife was given possession of the house as long as she made the mortgage payments and any other payments and made the repairs, and they were going to, in good faith, put the house up for sale and split the proceeds 50-50 from having an open market sale by a real estate agent. Well, it turns out the woman didn't make the payments. They had the sheriff's sale. I bought it at an open auction, and turns out that the attorney for the woman filed a lis pendens for the divorce action here well, she was in Georgia, but she filed the lis pendens here in Huntsville, and the attorney also filed a lien in the name of the wife, even though she didn't own the house, but against the house for her half of the proceeds from the divorce. I want to know, now that I'm selling the property, do I have to give half of the money to that attorney for that lien?
That's going to be very interesting. I haven't had one like that.
That's a tricky one. I will say this, you start with the fact that the court has the ability to divide up the equitable interest of the parties. And so absolutely, regardless of whether that property was titled, if they were married and going through a divorce or subject to that divorce, she has an equitable interest in that. And so most likely you are going to be subject to that equitable interest. My expectation would be is that probably needs to be pled into the case, the divorce case, and let the divorce court, along with whatever court is handling the division of the property or however you guys are handling that lawsuit, maybe they can communicate with each other and they can help solve this issue. But I do think the divorce court has the jurisdiction to address whatever her equitable interest may have been in that property.
They're telling us to take a break. We're going to take a break. Be right back answering more of your questions about family law tonight. Stay with us.
One Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Meservey, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. Tonight we are talking about family law, but before we get to it, so Timberlake, League & Brooks does something special at the Broadway Theater League. What is it that you guys provide for
We do. We sponsor what is essentially free wheelchair assistance to theater goers, and here's how it works. You call 256-551-2378 about 15 to 20 minutes before arrival, and one of the volunteer ushers will meet you with a wheelchair or assist you with your wheelchair, and they will also assist you during intermission and after the show. So
That's
helping
great.
folks get to the theater.
Appreciate that very much. So William Meservey is here from Timberlake, League & Brooks. Kobe Boswell is here from Next Step Family Law, and we're taking family law questions tonight. So divorce, child custody, and things like that. And William has got his list that he's going
We're
through.
only halfway through the list.
The family
We're
law
only halfway
questions
through the
that he
list.
gets hit with most often.
And so the
from his
next
clients.
one that I often get is 50-50 custody easy to get? Or what are my chances of getting 50-50 custody?
The courts try to do 50-50 custody as much as they can, but if they think the parents are not going to be able to work together, and the harder you fight against each other, the more evidence you're giving that y'all can't co-parent, that makes it more difficult. Judges may turn it and say, okay, y'all can't do it together. We're going to have to give one party primary physical custody.
And is that a newer development in recent years? It seems like in years past it was more difficult for folks to be able to get the 50-50 custody.
I would say in the past, the courts generally, and Madison County is much more liberal, but the courts generally lean toward women, toward moms, giving them primary custody.
I think in years past that's absolutely right. The statute's been there that joint custody is the preferred method for the courts to look at when they're dealing with a custody situation. So the starting point generally should be and is for the vast majority of all of our court systems, at least in this county, is the joint custody standard. But, you know, as Sharon said, if the parents can demonstrate to the court that they are not capable of working together, not capable of co-parenting with each other, there's no way the court's going to do a joint custody situation under that scenario. But certainly the court's preference is to start with a joint custody to give everybody an opportunity to try to establish that they can be joint custodians. And then if the evidence seems to demonstrate that they can't, then correct the situation from there.
And so if the court does agree, look, this is a situation where we can do joint physical custody and split time of the children 50-50, how does that work? Is it on a weekly basis? Is it on a monthly basis? Daily? You know, do you alternate days?
It's typically week on, week off, but it depends on the age of the child and what the court thinks would be appropriate for the child. Sometimes people are doing maybe a Monday, Tuesday to dad, Wednesday, Thursday to mom, and then they alternate the weekends back and forth. So you wind up with kind of a five. It just depends. But week on, week off is kind of standard.
Okay, good. So the next question that often I get calls about is from grandparents. And grandparents want to know when they can see their grandkids, right? And so they've heard that there's this thing called grandparents' rights. And they want to always know, what are my rights as a grandparent, and how do I enforce those rights?
Kobe, you take it.
You know, the grandparent visitation in Alabama is very limited, okay? And I don't think that a lot of people understand just how limited that area is. To get grandparent visitation in Alabama, you have to establish that you have a relationship that is above and beyond just a typical grandparent relationship. So you have to establish that you've provided some care for these children over the last certain period of time, that you're providing either day-to-day care, or you've established a very significant relationship with them that has a lot of activity or a lot of involvement with them on a regular basis. And even when you do that, then you have a very limited window to assert grandparent visitation rights under our law. The parents have the right to say, you know, look, we don't think it's in our kid's best interest for the child to go to the grandparents today, and the court's going to defer to their judgment in the vast number of cases unless the grandparent can meet this very small, limited statute and set of circumstances to get visitation.
One area that you see a lot of grandparents getting custody, though, would be when the parents are, neither one of them fit. So a dependency case. Describe what that would be.
Yeah, that's a totally different scenario, right? Now, a lot of grandparents come to us and neither one of the parents are capable, willing, able to care for their children. They have some sort of deficiency, whether it be substance abuse, you know, whatever it may be, homelessness, any kind of different scenario. But under those scenarios, a grandparent can go to the court and they can petition the court for custody of that child. Now, that's a totally different scenario if you can establish that that child is a dependent child, which means it has a parent or doesn't have any parent that is ready, willing, or able to care for that child. Then the court can vest custody with that grandparent and can place the child in the care of that grandparent and give that grandparent a lot of access to that child.
And so that's really more of a situation then where you're essentially trying to place the child, or the court's trying to place the child with a family member in lieu of having to place it with DHR in a foster
Correct. Absolutely.
home type setting.
That
Yes.
is exactly right.
And that's not going to be what folks would typically think of as grandparents' rights.
Correct. That's not what most grandparents want. Most grandparents want to be grandparents. They don't want to be parents again.
Yes, they want a weekend every so often. They don't want full-time custody.
Fair enough, fair enough. All right, so that takes us to sort of the next one on my list, which is, you know, everyone's heard if you don't have children, you can get an uncontested divorce. It's not, you know, if the parties agree, and it's not going to cost a lot of money, it's not going to take a lot of time. But I often get asked the question, you know, look, hey, we've tried to reconcile, we've done counseling, we're polar opposites, it's just not working, but we have children. We both agree we need a divorce, we both have an idea of how to split this up, but can we do an uncontested divorce with children?
You know, and the wonderful thing about our court system, I think our judges would even tell people, they would always encourage people to try to resolve things amongst themselves. So absolutely is the answer to that. You can always get an agreed, uncontested divorce with children, without children, no matter which way. It just requires you sitting down and resolving it. You can either get an attorney, each of you get an attorney, you can go to an attorney and have them draw up paperwork that can do that. But certainly, you know, the court would strongly encourage, and I think all attorneys would encourage people to invest in trying to resolve their case when it involves their children especially, because you can tailor a schedule or tailor to your kids' needs a lot more specifically than a court can spend the time to do that. We're talking about that week-to-week custody schedule. That might not work for everybody. Some people may work every weekend and they may need a different schedule that works. If you sit down and you can go through and you can reach that agreement, it will be better for you, it'll be better for your child. And the statistics will show that the chances of you guys avoiding court or being able to resolve smaller differences are significantly improved if you guys can reach an agreement.
Good.
The uncontested part is just meaning we agree on everything. So you could have an uncontested, whether there's kids or no kids, and many times people call us and say, I want an uncontested divorce, but my spouse doesn't. It's like, okay, we can't get you that one. You've got to agree, and you've got to agree on everything.
And uncontested can be negotiated as well, okay? So it doesn't have to be we agree on every single term or none at all. You can negotiate some of these terms and try to resolve it. That's what the attorney is there to try to help you think about some of the things that maybe you hadn't thought of before.
Well, I'm guessing that when you go through the divorce process and the child custody process, you know, your client really doesn't have a full idea of all of the issues that have to be sorted out, because we're talking about not just splitting up who's going to retain the house and who's going to, you know, deal with the children, but we're talking about splitting up debt.
Yeah.
Assets, who's going to, you know,
Who gets the dog?
is my mom's diamond ring still my diamond ring, or was it a gift that I gave, you know? So those issues get so meshed and convoluted that it's hard to peel them back apart.
Well, and it's emotional too, and so that's part of the process of going to the attorney to help them take some of the emotion out of it as well. Hopefully, that's the idea anyway.
Yeah. They're telling us take a break. We're going to take a break, and we'll be right back answering more of your questions about family law. Stay with us. We're not finished yet, but if we don't get your question answered tonight, Kobe Boswell with Next Step Family Law in Huntsville, 256-534-8799. Also, Next Step, which is NXT, FamilyLaw.com. Here's how to reach William Meservey with Timberlake, League & Brooks. They are personal injury attorneys, so car accidents, medical mistakes, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And Sharon Doviet, also practicing family law, here in Huntsville, 256-539-7337. You can find her on the internet at www.sharonfamilylaw.com. So we've got time for my last question, all right? And my last question that I sometimes get asked is, if I get divorced, can I move out of state? And specifically within the context of, you know, I've got a child custody agreement, but I've got this job opportunity out of state. It's going to pay more money.
Yeah.
What do I do?
It depends.
Yeah, and it's kind of hard. It depends on what you're wanting to do with the relocation. If you yourself, as a parent, want to relocate, you can relocate anywhere you want to. It's when you want to take your kids with you, it becomes a little bit more complicated. So in order to relocate in Alabama, you actually have to send some notice to the other party, give them some advance notice of the right to object to that, and then you have to go through a court process to get court permission to relocate with your children. So it's a pretty formal process.
Go see a lawyer and don't miss those deadlines. Thanks for all your questions tonight. We'll see you next week.
Have a great night.